Hello class, it's JB. Are you ready for another case? Today we're gonna talk about Filcar Transport Services versus Jose A. Espinas. Do you like cars? Do you like your crush? Put them together and this case is just for you. So the case all started when Jose was just driving around in one of the streets in Manila, and when he passed an intersection, boom! Okay, it wasn't that intense, but he got bumped by another car, which caused his car to flip. The other car managed to get away from the scene of the incident, but Jose actually saw the plate number of the car. And after verifying with the LTO, it was discovered that Filcar was the one who owned the car that bumped Jose's. After sending several demand letters, Jose eventually filed a case for damages against Filcar and its president, Carmen Flor. Filcar argued that although it is the registered owner of the vehicle, the car that hit and bumped Jose was actually the car assigned to their corporate secretary, Attorney Flor. And at the time of the incident, the car was driven by the personal driver of Attorney Flor, Timoteo Floresca. So Filcar denied any liability whatsoever. It was like, no, I cannot be liable because the driver is not my employee, but the employee of Attorney Flor. And with that, it's time for the lower court rulings.
METC.
The METC ruled in favor of Jose and held Filcar and Carmen Flor jointly and severally liable.
RTC.
Affirmed.
CA.
Now, the Court of Appeals, on the other hand, partly granted the petition. The Court of Appeals modified the decision by saying that the liability does not attach to Carmen Flor, the president and general manager of Filcar. Because what did we learn in corporate law? I'm asking, what did we learn in corporate law? We learned in corporate law that the liability of the corporation is not the liability of its officers and shareholders because the corporation is a separate and distinct personnel. Thus, the liability cannot attach to the president and general manager. The CA, however, affirmed the liability of Filcar. The court basically told Filcar, hey Filcar, even assuming that there was no employer-employee relationship, you're still liable under the registered owner rule, which makes you primarily responsible for damages done to third persons. The court then denied the MR of Filcar. So what's the issue of this case? Well, the issue of this case is whether Filcar, as the registered owner of the car that hit Jose, is primarily liable for damages. How did the Supreme Court decide the case? Yes, the Supreme Court ruled that Filcar is deemed as the employer of the driver and is thus vicariously liable under 2176 in relation to 2180 of the Civil Code. There is no dispute that the registered owner of the vehicle that hit and bumped Jose's car was Filcar, and that fact alone is the basis for Filcar's liability. As a general rule, one is only responsible for his own act or omission. Hence, he can only be held liable for torts committed by himself and not of another. However, there are exceptions to this. One exception, of course, is when an employer is held vicariously liable for the torts committed by his employee. Again, the core argument of Filcar is that the driver is not my employee, but the employee of Attorney Flor. Thus, those provisions cannot apply to me because those provisions presupposes an employer-employee relationship. The Supreme Court disagreed and explained that in motor vehicle mishaps, the registered owner of the vehicle is deemed as the employer of the tortfeasor driver and is made primarily liable for the tort committed by that driver. The Supreme Court even cited a case wherein the court held that as far as third persons are concerned, the registered owner of the vehicle is the employer of the negligent driver and the actual employer is only considered merely as an agent of the actual owner. Thus, it is sufficient to establish that Filcar was the registered owner of the vehicle that caused the damage in order to be held vicariously liable under the law. But what is the reason for this rule, you ask?
What was the reason? What was the reason?
It has been explained in a previous case that the main aim of motor vehicle registration is to identify the owner so that if any accident happens or that any damage or injury is caused by the vehicle on the public highways, responsibility therefore can be fixed on a definite individual, the registered owner. This is to avoid the inconvenience of finding the person that should be held liable. So whether there is an employer-employee relationship between the registered owner and the driver, it is irrelevant in determining the liability of the registered owner who the law holds primarily and directly responsible for any accident, injury, or death caused by the operation of the vehicle in the streets and highways. This is also to avoid situations wherein the registered owner can avoid liability by pointing fingers at their driver, who is less likely or unlikely capable of paying these damages. Filcar also cannot use the defenses available under Article 2180. The employee acts beyond the scope of his assigned task, or that it exercised the due diligence of a good father of a family to prevent damage. The motor vehicle registration law, to a certain extent, modified the provisions of 2180 by making these defenses unavailable to the registered owner of the motor vehicle. That means as long as Filcar is the registered owner of the vehicle that was involved in the incident, it cannot escape primary liability for damages caused to Jose. However, does that mean that Filcar no longer has a recourse? The Supreme Court here held that under the principle of unjust enrichment, Filcar can still go after the actual employer or the driver himself. The court closes out the case by saying that it may be inconvenient for the registered owner of the motor vehicle, but this inconvenience cannot outweigh the more important public policy being advanced by the law. Thus, the petition is denied. That is the case. Kisses from me, and see you next week, I think.